Hello, good afternoon. Welcome to the final session of Generation Renters' Rights Awareness Week. My name is Dan Wilson-Craw. I'm Deputy Chief Executive at Generation Rent, and I'll be chairing this session. We've got two excellent guests here to take you through one of a very little known right that renters have to claim back rent in certain circumstances. It's called a rent repayment order. And we have Al McClenaghan, who is here from Justice for Tenants, and Mohammed Williams, who's here from Tower Hamlets Council in London, to take you through what they do to support tenants who are in this position where they can potentially apply for a rent repayment order. We will have 10 minutes from each of them to hear about what they do, what you need to know as renters. We'll then have a Q&A session. So if you do have a question, please put your question in the Q&A. You can select to be anonymous, so you don't need to. If you don't want your name anywhere, that's fine. It won't appear anywhere. And you can stay anonymous in the Q&A. I think that's all we've got, all I need to take you through. So I will hand over to Al to get us started.
Al is on mute.
Okay.
Everything okay? You're on, Al?
There we go. Can you hear me now? Sorry, my
Yes. Yeah. Oh no, you're back on mute. Sorry.
How about now? Can you hear me?
Yeah, that works. Yeah.
Sorry about that. Having a moment there. Let me just share my screen, share my slides. Assuming my Zoom doesn't have more issues. If it does, I might ask someone to share my slides for me.
Okay. It normally takes a couple of minutes it feels like a couple of minutes, definitely. It's changing on my screen though, so that's good.
Lovely. While my slides are loading, I will just mention kind of my experience in this area. So I'm Al McClenaghan and I work at the non-profit organisation Justice for Tenants. I've represented tenants in rent repayment orders maybe 100, 150 times in the first tier tribunal and in the higher tribunals. So I'm just going to explain what the current situation is for rent repayment orders, but then I'm also going to talk about what will be like after the Renters' Rights Bill, which we expect to get royal assent in the next couple of weeks. So this isn't an exhaustive list, but what you see on the screen there covers about 99% of all rent repayment orders. If you've been unlawfully evicted or harassed by a landlord, you can claim to recover rent. If you're living in an unlicensed HMO, so that will be a house share where there's 5 of you and you're not all part of the same household, which basically means like part of the same family. And in some places, usually in cities, parts of London, other big cities, Oxford, Birmingham, etc. If you're sharing and there's 3 of you and you're not all part of the same household, maybe you're friends or maybe you don't even know each other, sometimes that council will require an HMO license as well. Or in some, again, cities, I think it's only in cities, some cities, parts of cities have selective licensing. So every rental property needs a license in certain areas. The landlord doesn't have one of those, you're entitled to recover your rent back. And in some circumstances, if there's really poor conditions, the council will have come round, served something called an improvement notice, which says, here are the faults in the property, here are the work you must do, and here is when you must do it by. And if they don't do it in that time frame, you're entitled to a rent repayment order. The vast majority, 97, 98% of them are for licensing breaches. Right? And in a HMO, a house of multiple occupation, a house share, doesn't have the required license, or I'm just in a property maybe I'm just living there or living there with a partner, just the two of us, but it needs a license. They don't have it. After the Renters' Rights Bill, there will be a number of new offences. Some of these require the local authority to have taken action first, but there are other bits in the Renters' Rights Bill that mean that the local authority by law has to do legal action when the landlord's broken the rules. So there'll be a new landlord ombudsman. So every landlord will need to be registered with an ombudsman when they rent a property or list a property for rent. If they don't do that, the council by law will have to fine them. If they've already done that, and then the landlord's still not registered with the ombudsman, you'll be entitled to a rent repayment order. Similarly, there's something called the private rented sector database. You will be able to search this database. If they've already been fined by the council for not being on it, or putting false information on it, then you're entitled to bring a rent repayment order. One here called knowingly or recklessly misusing a possession ground. That's basically they use a ground to get the property back that isn't valid. So an example would be there won't be any more Section 21 notices. If someone served a Section 21 eviction notice, that would be misusing the possession ground. That would probably be grounds for a rent repayment order. And then abusing, there's no more fixed term tenancies after the Renters' Rights Bill, no more no fault Section 21 evictions. But there are two new grounds where a landlord can get possession of their property back, even if you haven't done anything wrong, you haven't breached a tenancy agreement. One is they're selling the property. The other one is they're moving in, or their close family are moving in. If they use those grounds to evict you, and you see that property listed for rent within 12 months after that point, or if it's rented, if you can prove that, you're entitled to a rent repayment order. So it can be very sensible to set up an alert just for that specific postcode, exact postcode, on Zoopla or Rightmove. You'll only get alerted if a property in that exact postcode comes up for rent. Chances are it'll probably be your property. If you gather that evidence, you'll be entitled to a rent repayment order. And there are some changes, what's called tenancy reforms. So no more fixed term tenancies. You have to get a written tenancy agreement. The landlord's been fined for not doing that, and they do it again, you're entitled to a rent repayment order. And I'll just mention, having seen how this legislation has come about, being quite involved in it from the central government side as well. A lot of these changes, in fact, pretty much all of these and these new offences, there wouldn't be rent repayment orders for them, and the other good changes wouldn't have happened but for the work of generation rent. There's no doubt that those two things are exactly linked. No generation rent, none of these are there. So at the moment, you can apply for 1 year of rent, and you can do that up to a year after you've A, been living in the property, and B, the offence occurred. After the Renters' Rights Bill, you can apply for up to 2 years rent, 24 months of rent, and you'll be able to do that up to 2 years after the offence has occurred and you've been living there. So if on the 1st of February 2026, you move out of a property and it was an unlicensed HMO, you would have until the 31st of January 2028 to apply for a rent repayment order, and you could apply for a full 2 years, the last 2 years of rent when you were staying there. That means that you can afford to wait until after you move out, which is quite helpful because it could be a bit stressful applying for a rent repayment order while you're still living in that landlord's property. And sometimes landlords can be a bit difficult about returning the deposit. So it lets you move out, get the deposit back, and then take action. And this action is designed to be used by tenants because there needs to be a deterrent for landlords operating unlawfully. It's designed to be widely used by tenants. It's a means of regulating the private rented sector, not just for yourself, but for any future tenants of the landlord. How much gets awarded? Well, it depends. The range of awards is broadly between 30 and 100%, and it depends on a number of factors, and it will depend on a number of factors even after the Renters' Rights Bill. Has the landlord been convicted of this offence before already? And also, how do you present the evidence and argue it in the hearing? So you want to show you've had good conduct. You need to put evidence forward to say, I have not breached the terms of the tenancy agreement. I've paid my rent is all up to date. You need to make that case. And you need to link some of the landlord's poor behaviour. Here's where they harassed me for this. Here's where they tried to deduct money from the deposit. It went to the dispute service found the landlord was unreasonably holding money back. Or maybe there wasn't an HMO license, and in fact, they didn't give me the gas safety certificate. That's the breach of another bit of law. They didn't have fire safe doors, didn't have hardwired smoke alarms. So it wasn't just that they didn't get this piece of paper. We didn't have the protections that would have happened if they'd have got the license. You present those well, you get closer to the 100%. If all you do is kind of prove the breach, maybe you get a bit closer to the 30%. And what's the process look like? So it starts off with the rent repayment order application form, which you can download from the government website. That form's very straightforward. It's very easy to fill in. After you do that, the tribunal will send you what's called directions. And this is a 5 or 6 page list of instructions for you and the landlord, saying what you each need to do and how you need to do it. And there's often, once they actually send you the directions, there's often not that long to do the various steps. So it can only be 3 or 4 or 5 weeks before you have to submit your full evidence bundle. And that's the narrative of what has happened, proving that the offence has occurred. And it's really important that you really do this properly, because everyone can know, you can know, the landlord know they've broken the law, but you have to prove every element of the offence to what's called the criminal standard beyond a reasonable doubt. There will be, for an HMO licensing offence, a specific test you need to say is proved in a part of legislation. You need to go through each of those parts and prove each limb. The landlord doesn't actually have to prove that you're wrong. They can just argue, you haven't proved it to the criminal standard. So proving the breach is really important. The threshold is really high. It's very achievable. You just need to be a bit careful with that. You also want to put all your evidence of the bad conduct. So it's not uncommon for there to be 10 or 11 pages of writing, maybe 150 pages of exhibits, photographs of WhatsApp communication, screenshots of WhatsApp communication, stuff like that. Then the landlord has a few weeks to give their evidence bundle, and then you normally have a couple of weeks to reply to it. And usually you'll want to then also give like a 1 or 2 page, what's called skeleton argument, something a tribunal judge can hold in the hearing and follow all the points that you're making, the key parts of it. And if you're relying on any what's called precedents, to say, you must find they committed the offence because this precedent, this previous case says this. You must award 90% of the rent, not 60%, because of this case, which said that. You need to provide those before the hearing. And there is a hearing. It will almost always be an in-person hearing. And it's just important to note that while you may have put all your evidence there, you still have to go through all your evidence. You can't assume that the judge has read it and will take it as fact. You have to present your evidence, and then you'll need to cross-examine the landlord on any inconsistencies on their evidence, and then make an argument as to why the offence is made out and why a large amount of rent should be awarded. So at JFT, we carry out the majority of rent repayment orders. We do about 550 a year, representing about 2,000 tenants. We also do have agreements to do this for about 80 local authorities as well. The way it works is our team will basically do all the steps. We'll draft the application, send it to you, ask if you've got any questions, make any changes, submit it. Same with the evidence bundle, same with the response. And we have 4 full-time advocates, 2 part-time advocates to do all the talking and arguing at the hearing. We're a non-profit. The service just needs to run at a break-even level. And to make access to justice a bit easier, we pay all the tribunal fees on your behalf. They're not much by court standards, but they are reasonable. They're about £350. And the way we're structured is, we win about 99% of cases. If we lose, you pay nothing, you don't pay back those tribunal fees. If we win and you receive the money, we will charge 30% of that money. If we win and the landlord's not paying, we don't charge anything, you don't pay back the tribunal fees. But we have got a solicitor's firm that's going through the authorization process that will exist just to make sure if someone doesn't pay, we can force them to pay, put what's called a charging order on their property, and if they still don't pay, basically sell their property without their consent to recover the money. I think I'll leave it at that. Apologies for those issues I had with the screen sharing.
Thanks very much, Al. That was very comprehensive, and yeah, hopefully that was really useful information for our audience. I'll hand over to Mohammed now, and I'll then we'll get into the Q&A. So, Mohammed, yeah, really keen to hear how things are from Tower
Thank
Hamlet's
you.
perspective.
Thank you. My name is Mohammed Williams, and I am the Rent Repayment Project Officer for the London Borough of Tower Hamlets. The council started assisting tenants to claim RROs with funding from the Ministry of Housing, Communities and Local Government in April 2019. One outcome goal of the project was to claim a total of £20,000 on behalf of tenants. But in the first year, we were able to claim 116,000. So our director of service was pleased with the work we did and then decided to give me a permanent contract to work on the RRO project. Since April 2019, we have claimed a total of about 1.5 million on behalf of 233 tenants in Tower Hamlets. So this means, following on from what Al said, you can really claim RRO if you put your mind to it, or if you live in Tower Hamlets, the best thing would be to contact us. If outside Tower Hamlets, you can contact Justice for Tenants. I routinely refer cases to them as well. And we claimed, out of this, we claimed 981,000 for tenants residing in properties which required additional licenses. The council introduced the additional licensing scheme on April 1st of April 2019, and it was renewed on the 1st of April 2024. And the additional scheme will expire in April 2029. And the additional scheme applies to smaller HMOs, 3 or 4 tenants, forming more than 1 household, properties with shared facilities, flats above shops also fall under our additional licensing scheme. And if you pay rent to your landlord as well. And from April 2024, our additional scheme will be operated borough-wide. It was initially, it did not apply to our selective licensing areas, but from this period, it now covers the whole borough. I'll get to the selective licensing scheme. And a household is defined as a single person, members of the same family, couple, siblings, parent, and child. So 5 unrelated individuals sharing a house will be 5 households. We also claimed 402,000 for tenants who resided in premises which required a selective license. Our selective licensing scheme covers Whitechapel, Weavers, Spitalfields, and Bangla Town. It applies to all privately rented properties which are occupied by 1 household or a maximum of 2 households, comprised of 2 occupiers in the areas I mentioned. The selective scheme was introduced in November 2016, was renewed in October 2021, and will now expire in September 2026. There are plans to extend the selective licensing scheme across the borough, following the lifting of restriction on the scope of selective licensing schemes by the government in December 2024. We also claimed 86,000 for properties which require a mandatory HMO, which is what most people think about when you mention HMOs. A property is classed as mandatory HMO if it is occupied by 5 or more people, forms 2 or more households, tenants share facilities such as a kitchen, bathroom, and toilet. They pay rent to the landlord or managing agent. And this applies whether the tenants are on a joint tenancy agreement or on separate agreements. And they must occupy the home as their home. Because I believe I discussed this with Al before. I had a case where we went to the tribunal and one of the tenants, the landlord, was able to prove that he was operating a business from the premises. So our case fell apart because of that. Our health and housing team, I form part of the health and housing team. We receive inquiries and complaints from about HMOs and, for that matter, RROs daily. Our support team will routinely refer these to me. On receiving an inquiry, I check on our case management system whether the premises has a license or not. If there's a license, I note when the landlord applied for a license. I believe I'll address this as well. I then respond accordingly. If the tenant can claim RRO, I send an information sheet and I email about how we can assist. I also explain that it takes time to claim RROs, just so that they know if they are in a hurry. What I tend to do is to refer them to Justice for Tenants. A tenant can claim RRO within 12 months of the date the landlord applied for a license. The other condition is you have to make a claim with a period not exceeding 12 months during which the landlord was making the offense. And this normally is able to catch people out. I believe I was caught out a few times when I started with this. It was Al who actually pointed this out to me. So if you left the property over 12 months ago, after the landlord got a license, it's likely that you're making an invalid claim. And this is, it's not very clear. If you look at Housing and Planning Act, Section 44(2), it's not very clear, but that's what it says. The process starts after I've collected supporting evidence from the tenant. This includes a tenancy agreement, evidence of rent payments. It will be a bank statement showing the payments you made to the landlord. I then complete the rent statements. A rent statement will just be a Word document stating the month, the date you paid the rent and the month you paid and how much you paid. If you are eligible to claim 12 months, the rent statement will show 12 months of payments. I then state at the bottom of the rent statement when the landlord applied for a license, or if there's no license, I just leave it there, or when the tenant left the premises as well, just so that to guide me when I'm doing the case bundle. I then complete the RRO1 form and send back to the tenant to go through sections. Section 9 is the most important one. That's where you have to state the grounds for making the claim. So you state the grounds, you state the period you're claiming, the amount you claim, and also if you know the date the landlord applied for a license, you put it there. If there's no license, then you state there. So that part is very important. As long as you get the RRO form, section 9, if you get that correct, if you get all your information in there, then you are partway through the claim. The other issue we've had is about who the respondent is. This it became really difficult after the Supreme Court decision, which said that you could only claim against an immediate landlord. So for this, if for example, you living in a property which is operated as a rent-to-rent scheme, you may actually struggle to do that. Initially, we could just add the name of the owner of the premises, and we do that because if the other party does not pay, you can have the debt charged against the premises. But now what happens I've got a case on Monday, and it's a rent-to-rent case. When I filed the claim and notified him, and he was responding, he said this, that, and that. But after a certain period, he's just gone quiet. He did not submit a case bundle, and it's not likely he's going to attend the hearing on Monday. So in a situation like that, I've checked Companies House, and he's already closed down 2 companies he operates. So these are some of the problems you may face. So if you're doing it on your own, maybe the best thing to do, if you live in Tower Hamlets, contact us, the council, and we can help you with all these things. If you live outside Tower Hamlets, the best agency may well be Justice for Tenants as well, to help you through your claim. But you can, most tenants can do it. I've had a few who did it on their own, and they came back to me and said, look, I was very successful with my claim. And I said, oh, thank you. You've done so well. That's good. And you would notice that I've left out, you can claim RRO for illegal evictions as well. But we rarely get this because we, in the council, they are competing, interests, because if somebody is illegally evicted and contacts the housing options team, what happens often is their main aim is to get the person back into the property. So most of the cases I've had referred to me from housing options, they come back to me later and say, look, Mohammed, we're able to get the tenant back into the property. That's their overriding distance. So it's not likely we get many cases from housing options. I've had other few cases for illegal evictions, but there was one I took to the tribunal. After I submitted the case bundle and everything, the tenant just vanished. I never heard from the tenant again until about 2 or 3 months after the hearing. And then she contacted me to find out what happened. And I said, oh, look, I sent you emails. I sent you a copy of the case bundle. I sent you emails and everything. And she said she never saw them. So most of the claims we've made in Tower Hamlets are to do with RRO for unlicensed premises. So if you live in Tower Hamlets, you can check on our website. There is a register of landlords. Check there whether your premises has a license or not. If there's no license, still contact us, and then we will check, because sometimes we take time to register properties that have been licensed. So it's possible you could check our database and not find the property. But when you contact us, we will do the proper check and then let you know. We also, we don't charge for the service we offer in Tower Hamlets. We pay the fees, and if we are successful with the claim, you pay us back for the fees. I believe now it's about 117 for a tenancy agreement, and then 227 for a hearing. But more often than not, if we go to a hearing, then it's likely we'll ask the panel to pay us back the fee. So the landlord, if we are successful, the landlord pays the council the fee. So more often than not, tenants don't pay anything. The other thing I would like to talk about is mediation. You have the tribunal offers mediation services. If you're doing it on your own and you think you don't have a legal, you think you may struggle with the case bundle, then if the landlord agrees to mediate, the best thing to do is to accept that there are very good mediation officers at the tribunal. And then you can also settle with the landlord. So it's always good to put in a claim. If you put in a claim, notify the landlord that you've claimed RRO. It's likely the landlord may go to a solicitor, and the solicitor will say, look, I've seen this a valid claim. Let's settle. So if that is offered as well, it's always good to accept that and then try to reach a reasonable settlement amount. But I'm not very keen on mediations, because the last mediation I went through, we were there for almost the day and we didn't reach an agreement. So I prefer settlement to mediation. But if you are not able to settle, then go for mediation and just see where it goes. You can always walk out and say, look, we don't accept what is offered. So I believe I'll end it here. If there are any questions, then we could look at that.
Great. Thanks very much, Mohammed. That was really, really interesting, really good to hear about those different ways it might go. Particularly, settling. I was going to ask about that. I mean, I'm interested to hear from both of you what you find what proportion of the cases do you deal with that do get settled compared with that go to a hearing?
Yeah, well, I mean, with that, we got quite a lot of data on this now from over the years. Because of our reputation, if a landlord goes to one of the big solicitors firms, they pretty much always settle, because we have a perspective where if we're representing tenants, because of the way our service works, there's no reason why the tenant should accept less than we expect that they would get in a hearing, because they're not paying for our time, that they pay a percentage of what comes back. And so we will always say, here's what we expect to get in a hearing. Unless you really don't want to have a hearing, there's no reason to accept less than that. And from the landlord's perspective, if the more the case goes on, they have to spend £250 an hour on a solicitor, £4,000 on a barrister. So they're really incentivized to settle. And the tenants we represent have no incentive to settle for less. So because the solicitors firms, the big solicitors firms know how we work, they will pretty much just tell their clients, look, there's no point lowballing, because we know what the case is worth. We know JFT knows what the case is worth, and we know JFT is going to tell their clients, here's what we think it's worth. There's no financial reason you should take less. So often it will settle at maybe around about 75% of the rent. So we settle about 2/3 the cases, but with the big national solicitors firm, we settle about 95% of them. The ones we don't tend to settle are often where the landlord doesn't get legal representation, so believe that they can explain to the tribunal, oh, well, here's the reason why, or I didn't know about HMO licensing. And the problem is that they're actually just shooting themselves in the foot, because that's the whole point. You're meant to know about it. And if you're saying, look, I had no idea, I don't do anything to find out about these rules, that's bad conduct, and that often leads to higher rewards. So it's about 2/3 settle. I dare say if you were willing to take a lower amount than you would expect to get in a hearing, you could get that number up to 80%. There will always be about 20% of landlords who just, in their head, I'm not a criminal. I couldn't possibly have committed a criminal offence. It must be the tenants who are unreasonable. The tribunal will surely understand, and then they're not really willing to settle at any kind of reasonable amount. They're the ones who tend to get 85, 90% of the rent awarded. So you can probably settle about 3/4 of cases if you're self-representing, if you're willing to take a significantly lower amount. We settle about 2/3.
I mean, we settle about, I believe, if I can put a percentage on it, about 55% of our cases. And normally it's between, we are different from Justice for Tenants in this regard, so we can make a bit of allowance. I mean, sometimes I go back to the tenants and say, the landlord, this is what the landlord is offering. I think it's low. And the tenants will say, oh, look, we will take it. We don't want to cause a problem between the landlord and us, because we had a good relationship. So we will take 50% or 55%. But the average settlement we work in at is about 65% of cases. At 65% of the amount, that's where we settled at.
Thanks. I'm interested to know if so where it's a licensing offence. Let's say, I mean, we will generally say to tenants if they're moving, check if you're going to be living in a licensable area, and check if your property has a license. But obviously, they may be staying in that property for several years, and may not want to apply for a repayment order until they move out. Is there do landlords have to notify tenants when they do get a license, if they do get a license, or is there? It's just one of those things that tenants should check every year.
Sorry, if I can come in. Yeah, we do, because if most of our, if I can add this, most of our cases we get them through tenants, because tenants complain to the council, and then we're able to start there. So if the tenant complains and we establish that the premises hasn't got a license, we start sending warning letters, and the tenants will see that. We also send a copy of the letter to the tenant, not a warning letter, but just telling the tenant explaining what could happen if, because the tenant is living in an unlicensed property. we do that. So, and when the landlord applies for a license as well, we send a copy, a final copy to the tenants to approve. If they challenge it, then we can look at it again. So the tenants will always know this.
Yeah, and in kind of other parts of the country, it's actually fairly common that the council will find out that the property doesn't have a license, and the landlord will then apply for one, and the council will write to the occupiers of the property, but they'll send a letter which just says to the occupiers. And so quite often the way a tenant comes to us is the landlord will have said, oh, I'm expecting some correspondence to the occupiers, don't open it, I'll come round and collect it. And the tenant goes, well, hang on, it's for us. And they get a bit suspicious and they look at it and they go, this is what's happened. And that's how they kind of find out about it not being licensed. Whereas, to be honest, if it's just I think a lot of the time, if the landlord was upfront and honest, there'd probably be less of an issue. But tenants should be notified, but often that will just be a letter that says to the occupiers. And I don't think every local authority always does, even though they should notify them if a license application's been made.
Thanks. And we've had a few questions in the Q&A, so I'll just go through them. There's one person's actually, it sounds like they've applied for one and they've had directions through and they're preparing their bundle. I don't expect you to provide individual advice to our audience, but in terms of but for anyone who's preparing a bundle at the moment, are there particular things they need to make sure they include? And also there's a question, sort of practical question, do they need to copy in the landlord or the landlord solicitor when they're sending it back?
Yeah, so with the bundle, there's kind of a few different kind of steps to think about it. So number one is you need to prove the offence has occurred, and that means, and I think Google can be your friend here, or ChatGPT, to say what are the parts that prove, an HMO licensing offence, for example. And then make sure you understand each of the bits of legislation. There is a lot of information out there, and prove each of the parts, and there are multiple parts. Secondly, you then need to prove the rent that you paid, as Mohammed said, that kind of rent statement. Here are all the bank statements showing all the rent payments, and here it is in a nice Word or spreadsheet format, date of payment and amount, what period of time that was for. The 1st of January, I paid £2,000 for the rent. Between the 1st and the 31st of January, on the 1st of February, I paid the rent for the next month. After you've kind of proved that you're entitled to bring a rent repayment order, you've proved the breach, and you prove that you're entitled to a specific amount of rent, you also want to prove that you haven't made an oversight. So you want correspondence from the council where they say not only is there no license, but we haven't had any license application. And then the other parts you want to look at are what's called conduct. Conduct's really important. If you don't talk about it, you might only get awarded 25%, but if you do, you can get 85% of the rent. So you need to make a statement which is, I have complied with I've been a good tenant, I've complied with the tenancy agreement, I've paid my rent, there's never been, complaints that have been raised during the tenancy. Meanwhile, here are all the issues with the property, with the landlord, with the agent. And if you can, and if you can't, it's okay, because this is more if you're able to dig into the law. Point out all the bits of law that have been breached. It's quite common that you said, well, I wasn't given a gas safety certificate or an energy performance certificate or a how to rent guide. These are the bits of legislation that it's breached. There was not a fire alarm hardwired on every floor and in every room. That's a breach of this bit of legislation. If you can do that, that's quite helpful, because from the tribunal's perspective, it's poor conduct if there's bad conditions, but really it's poor conduct if the landlord breaking multiple laws. Because then it's not the argument a landlord will say, oh, I didn't know, but I'm a good landlord. And it's like, well, there's 7 different bits of legislation that you breached there. So what exactly makes you think that a good landlord can breach all these laws? So it's prove all the parts of the breach, prove the rent that you're entitled to, and then prove your good conduct and their good conduct is how I would say is a good way to lay it out.
I presume that not having had the How to Rent guide, for example, might be hard to prove, because I know that landlords will sometimes kind of get you to sign something to say that you had received it, and that might be something they can come back with. But I guess you just saying that and the landlords not being able to prove that they have given it might be enough for the tribunal. It's not something that you have to prove in terms of
Exactly.
You have to prove everything else as the criminal standard.
Yeah, exactly. What the tribunal will decide for these kind of what's called tertiary issues, and not, it doesn't matter if you've proved or not, the offence has still occurred, is whose evidence do they believe on balance? Who do they think is more likely telling the truth? And particularly if you cross-examine the landlord well, if the landlord is seeking to kind of mislead or isn't being honest, the tribunal's pretty good at telling, because they do a lot of these hearings. They know who's being honest often and they know who's not. They might not let that slip in the hearing, but it's very, very common that you'll finish a hearing and think, I don't know if they believe me about that or the other. And then the decision comes through and they'll say, we found the tenants to be credible, honest, straightforward witnesses. On the other hand, we found the landlord to be evasive and we prefer the tenant's evidence that they did not receive this. And that will be the decision that they make. So often the landlords who are kind of not upfront and not honest, the tribunal can tell.
Yeah.
I believe the person who asked the question, I think there will be a section as well, full details of the alleged offense, and then an expanded statement showing why you're making the claim. Maybe the best thing to do will be to contact the local authority and just see what evidence, why, maybe if, for example, we have an additional scheme on our website, we explain why we started that. So if you look on our website, you will get information to put into your expanded statement. This is why I am doing the claim. And also fire, I believe I'll help to, and if I could just say something, when I started the role, I didn't have any idea about RROs. It was Al. I went to them and then I spent half a day with them and they taught me how to do the bundle and everything. So yes, always grateful to Justice for tenants. I will still continue to work closely with them. Yeah, so go onto our website, check, you will get information why the council started the additional scheme or the selective scheme, and then use that as part of your statement in the expanded statement while you're making the claim. And then also witness statements. You have to submit a witness statement as well. State when your tenancy started, the number of rooms, the number of tenants at each time throughout the claim period. You have to show that depending on the type, if it is additional in tower hamlets, you have to show that there were 3 tenants or 4 tenants throughout your claim period. Try to show this in your witness statement and then sign it off with the statement of truth. If you faced disrepair, state that as well. How did the landlord respond quickly if you complained? All these things should be there. Did you pay a tenancy deposit? Was it protected? You can put all this in your witness statement. And also the conduct. Al has touched on the conduct of the landlord. That can go in there as well.
Thanks. You mentioned other tenants. Is it important that if you're in an HMO, particularly in a large HMO, where you might not actually know your housemates very well, is it important to have them involved in the application as well? And is that essential, essentially?
I mean, I would say yes, it is important. Whether it's essential or not will depend on the specifics. So if it's you need to prove there were 5 occupants and there's 4 of you who are taking the claim, and you can say, look, this person was there, they were there almost every night. It was their main place of residence. They were there for a year. I spoke to them. They never mentioned living elsewhere. It's probably fine. If you're the only person bringing the claim and you don't know the last name of anyone else, and you can't be sure about what the dates are, chances are you don't quite have the criminal standard of evidence to bring it. So I know in general, in our rent repayment order team, it's quite rare that one tenant can prove an HMO licensing offence, but they'll generally, if there's good evidence and there's 2 tenants, they will think that that's enough. It's just that's the kind of time where you can't be certain if you'll be able to prove it. If there's 4 of you out of 5, that'll be fine. If there's all of you there, that's the best. And it's sometimes worth mentioning to the other tenants that once we bring this rent repayment order, if you don't apply for your rent back, the act of me bringing this means that you will never be able to apply for your rent back because the case will already have been heard. But I know sometimes if tenants haven't heard of rent repayment orders, they think, no, you don't get money for nothing. So this can't be true. But the reality of it isn't. It's money to deter landlords from committing criminal offences, licenses, improve standards, improve conditions, improve fire safety. But that isn't necessarily how it can feel. So the more tenants, the better, but it isn't always required, is my perspective.
Yeah, great. That's really helpful. Just looking at the other questions we've got. One is, assume selective licensing doesn't apply to lodger/guest period arrangements. Please advise. So.
Yeah, in general, that's correct. If you have one lodger, it doesn't apply. If there's something like if you get to above a certain number of lodgers, it can apply. But I'll be honest, I'm not 100% certain with selective licensing. I know if, say, the landlord lives in the property and they have 3 lodgers and there's an additional HMO licensing scheme in place, then that's a breach of HMO licensing. I know that's the case. When it comes to selective licensing, if you are just a lodger living with the landlord and you're the only lodger there, I'm pretty sure the landlord doesn't need a selective license. If there's 2 lodgers in that area, I'm not sure of the answer on that.
I believe Al is correct. Yes, in our case, I mean, now we're changing the definition of we've changed our selective scheme. So maybe 2 lodgers, no, you won't be able. I don't think we'll license that.
Okay, thanks.
Yeah.
There's a question here. It might be a quick one to answer. Is there currently a way for the Renters' Rights Bill to claim rent repayment for the damp and mold / repairs that went unfixed in a previous tenancy that's now ended?
No, unbelievably, if you've lived with damp and mold, that doesn't entitle you to a rent repayment order. It's staggering. There is legislation coming in called Arab's Law, which is to do with dealing with repairs, which, again, thank you, Generation Rent, that will be applying to the private rented sector. But that's not going to come in for a good few years. At that point, depending on Generation Rent's campaigning, it may well be they bring in a right to a rent repayment order if you've reported damp and mold and it hasn't been fixed in time. But at the moment, no is the short answer.
But the judges are looking at these cases seriously. This time, I've got some of the judges, if you submit evidence of mold and damp, they take it seriously and they may well increase the amount you're going to get.
Yeah. So what Mohammed is correctly saying there is if the ground is you didn't have a license, that's the breach. But if you prove, and if you can prove that, if you then can provide evidence showing, look at the damp and mold, if it's really bad, you're going to be getting 90% of the rent there, because it's so harmful, damp and mold, and they're alive to that. It's a very good point, Mohammed.
And is there, you mentioned there's the improvement notice, the failure to comply with an improvement notice. So presumably if there's an improvement notice that has been served on the basis of damp and mold, and then that you've moved out, but it's still, maybe it hasn't been, there's still potentially a case there if that's noticed.
Yeah, there is. If the council serves an improvement notice, it's then not done the period of time that they haven't dealt with it when they needed to, you can apply for a rent repayment order. The challenge of that is most circumstances, you will have moved out and found alternative accommodation for your own health. And also it's like, okay, they haven't complied with the improvement notice. They should have complied with it 5 days ago, but you can only actually apply for 5 days rent. So you have to live with that damp and mold for a long time. So they're quite rare, but you are correct, Dan, that is how you can do it. It's just also a lot of councils don't serve improvement notices. They try and just deal with it informally.
Yeah. Interesting question that's just come in. A tenant who's applying for a rent repayment order is asked if they can redact their current address and date of birth from evidence they submit.
Yes, but you need to apply to the tribunal for that, and you need to give a reason why. And it isn't a guarantee that they will say yes. There's this, and you might need to give a kind of what's called an alternative service address, which isn't your address. Mohammed's nodding. I know we've had some success with that, particularly when we're doing things to do with harassment and unlawful eviction. and the landlord is a particularly nasty character, and the fear of retaliation would prevent someone taking action, so they don't want to disclose their home address. We've been successful, but you can't just say, I'm choosing to do it. You have to get permission to do it. Is that in your experience, Mohammed?
Yeah, from my cases, what happens is that I used to use my own address, but a few of the case officers have challenged that. They said they prefer the tenants, and we have just to do what you do as well, unless, of course, you provide a different address.
Thanks. We're coming to the end, so I'll ask a handful more questions, but I don't think we'll manage to get through them all, unfortunately. One of the things that I'm aware of is that if you're getting your rent paid through universal credit or housing benefit, or at least you're getting support with that, it's a bit different. And actually, if you're getting all your rent paid through this, it's actually not worth applying for a repayment order. I think you can say on that.
Yeah, I mean, I was at what's called an APPG, an all-party parliamentary group in the House of Commons, where I was very much saying, look, if a tenant's living in poor conditions and most or all of their rents through universal credit, they should be entitled to recover that. The idea is to have more of this enforcement to deter criminality, but I wasn't able to have any success with it. If all your rent comes through universal credit, that's seen as the state's money, so the local authority can apply to recover that, but you can't personally recover it. So from your own perspective financially, you can only recover the rent that you've paid that hasn't come from historically housing benefit. Now it's called the housing element of universal credit. So if all your rent comes from universal credit, there is no financial reason for you to apply for a rent repayment order because you will not get any of the money.
But from our side, we prefer people come to us because the money will come. Because I mean, what we do in the council now, my pay comes from our budget, what we get for other enforcement actions. So if we got money like that, it will help. Maybe we employ somebody else to help me because I do all that alone. So, I mean, we've had cases like that. I contact the tenants and say, okay, we can help you. And then they say, oh, we claiming universal credits. Oh, in that case, the money is going to come to the council and they disappear. You don't get to see them again. But we prefer people like that. They come forward, we claim the money, and then we can help other tenants. I believe that will be the case for it.
And sometimes some of the rent comes from universal credit and some of it is privately paid. And there, particularly with local authorities, we've got agreements with, will cover the universal credit, and that money goes to fund more enforcement in the private rented sector to protect tenants, and then the privately paid rent will recover for the tenants as well. And we'll just make 2 applications and ask the tribunal to join them together in just one set of proceedings.
Yeah,
but
thank you.
Dan, if I can just come in, I believe there's a different process. If you want to claim for universal credits, you have to send a notice to the landlord as well, notice of intended proceedings.
Yeah.
So there's a different.
Right, that's helpful. Thanks. A question's come in about whether only you need to have a written agreement in order to prove a tenancy, and I'm also aware that that a lot of landlords ask for payment in cash, and yeah, interested to know what tenants can do in that sort of situation.
Yeah, this is a common issue. Unscrupulous landlords are more likely to not give a written tenancy agreement. So the position in law is that it doesn't actually matter whether your tenancy agreement is written down or not. So there's 3 hallmarks of a tenancy agreement. It doesn't matter what's in writing as well. It can say a holiday let agreement, but the reality is if you pay rent for a specific period of time, £800 per month, if you pay it in cash, for what's called exclusive possession of a bit of land. So either I pay you £800 a month for this 1-bedroom flat, or I pay you £800 a month for this room, and I've stayed in this room for 7 months. You've got an amount that you pay on a regular basis for possession of a certain area of property. That is a tenancy agreement. Doesn't matter if there's anything written down or not. It doesn't matter if there's something in writing that says it's a different kind of arrangement. There's a very famous case called Street versus Mountford, which lays out these hallmarks, and that still persists. So you don't need to have a written tenancy agreement. To be honest, what we found is that from the tribunal's perspective, if there's not a written tenancy agreement, it doesn't tend to work in the landlord's favour because it's a sign of poor conduct.
Thanks. Two more. I'll ask two more questions, and then we'll wrap up. Practically, is there? You mentioned you will need to go to a physical hearing. Are these? Do these take place in every city? Is there a lot of travel involved for people?
Yeah, so there's I think 6 different tribunals. There's one in London, one in the southern region, the eastern, the Midlands, the northern. I might have missed one out. So generally, if you're in a big city, there's a good chance that you don't have to travel very far, or it's fairly easy travel. If you're in a more rural area, you might have to travel an hour and a half. Quite a small country, the tribunals are generally in very well-connected places. So you'll know it'll be pretty unusual that you would ever have to travel more than say an hour and 15, an hour and a half to get to a local tribunal. And they usually start at the reasonable time of 10 a.m. To give people time to get there.
Great, thank you. And then final question I'll ask. I'm sorry if we've missed some questions, but we'll send an email out to the audience just to see if there's anything we can clear up afterwards. Final question was another one from the audience, just about enforcement. I know that once you've got the order, your landlord legally has to pay you, but they won't necessarily do that without a fight. What can you do, and do you think the ombudsman that's going to be created by the Renters' Rights Bill could play a role in that?
No, unfortunately. So we have to enforce for non-payment on something like £800,000 of unpaid rent repayment orders each year. So we've been doing these for about 8 years now. The ombudsman won't do that because there are civil proceedings. I won't go too far into the weeds, but in essence, it's the same as if anyone owes you any amount of money. So you have to convert it into a county court judgment. And then there are a range of enforcement options which you can use. But in practical terms, someone has a spare property that they're just using as a vehicle of their wealth expansion. They don't need it to live in. So almost always the most effective thing to do is to put a charging order on the property. Our approach is if you put a charging order on the property and the landlord's got a mortgage, just wait. When they try to remortgage, they submit the application, and then 4 months before their property is about to be repossessed, the mortgage company comes back and says, no, you got a charge, you're too high risk. We're not going to give you a mortgage. And then we get a very incentivized landlord who's all of a sudden in a rush to pay. And they might say, oh, I can pay you this amount of it. And you just say, no, sorry, pay it all or sell the property. Either way, pay it all. And amazingly, they pretty much stamp up the money rather than lose their property in that 4 months. If they don't have a mortgage, then that's when we consider something called an order for sale, which is where you sell the property without their consent because they owe money and you've got a charge and they're not paying it. This is one of, I think, the reasons why it is a bit more helpful to have representation for these matters, because sometimes you can win, but winning with a piece of paper saying someone owes you money isn't necessarily the same as actually getting that money. But yeah, you treat it like any other civil debt is the legal position.
Maybe just one last, maybe it's preferable to settle, because if you settle, you will get your money, certainly. The landlord is not going to refuse to pay it. That's one reason why I look at settlement as a way out of the claim.
Right. Thanks to both of you. We've got some links just with some further information, which we'll get up in a moment. But yeah, thank you to Al, thank you to Mohammed. Really, really useful information, and I hope that's really useful for our audience. Thanks to the audience for your great questions. Sorry we couldn't get through them all. We will be getting this up on YouTube, so if you've missed anything, then there'll be an opportunity to look back. please do, if you would like to help us with our campaigning, if you've got an experience you'd like to share, please come on our website and sign up to our mailing list. There's a share your story page as well, which we'd love to hear from you through. We have a prize draw at the moment alongside Renters' Rights Awareness Week. There are copies of 7 different books, mostly about housing, that you can win. So we've got a crowdfund page where you can do that. You can also enter for free. So please check that out. You've got until Monday noon to enter for that. And there's still time to sign up for our Renters' Rights Bill campaign, even though we almost have the final act signed off through Parliament. But you can sign up on the website as well to hear more about that. That's when we get the final news through. Thanks again for watching. Sorry, we're slightly over time, but really thanks again, Mohammed and Al.
Thank you.
And have a great weekend when it comes.
Bye.
Cheers. Bye.